Recapture. Thank you.
Right. Well, we've been talking about contract issues, and you know, your contract provides for the relationship between the writer and the publisher. But the Copyright Act also has two provisions that allow for a writer to terminate a contract. Notwithstanding anything in the contract that says this lasts forever or this lasts until you've delivered X number of compositions, there are ways to get out of a contract. It's a little complicated. There are a lot of hoops to jump through, and it's a long time off. You can't get out of a contract quickly this way. But there are two provisions in the Copyright Act, Section 304 and Section 203, both of which allow for termination of previously granted rights. So that if you've granted rights to a publisher and you meet all the statutory conditions of one of these provisions, you can terminate that publisher and go take your compositions elsewhere. Section 304 I'll talk about very briefly because it's a very long window of time and it only relates to works that were written before 1978. So a lot of works from the late 50s and early 60s are now coming into that window because it opens up at year 56 after the publication of the work. So if you've got things from 1960, let's say, 56 years is 2016, that's coming right up. And so things from that period are subject to 304 termination, and it's not automatic. You have to actually serve a notice on the original grantee and make sure that you identify what agreement it is that you're terminating. And there have been a number of cases on that, particularly in the literary world, involving John Steinbeck, involving Winnie the Pooh, involving some really successful literary works from long ago. The one that's getting a lot of attention right now is a shorter time window, and it's Section 203, and it pertains to works from 1978 on, actually for contracts that are entered into 1978 and later. And that is a window that opens up 35 years after the date of the contract. So it doesn't matter when the work was written or published. It's 35 years after the date of the contract, starting in 1978. If you do the math, 1978 plus 35 is 2013. So that is just now happening. And you're just now starting to get writers and recording artists who are challenging agreements that they made in the late 1970s saying, I want my rights back. And so far, there's been one successful case, somewhat successful, involving a guy who was a lyricist and one of the performers in the Village People, who terminated a songwriting agreement that he had because he was a co-writer on all the Village People. He was a lyricist for a lot of the Village People hits. And he was so far successful in asserting the right to be able to terminate that agreement. It does not apply to works made for hire, which is a real sticking point often in recording contracts because a lot of record label contracts will call everything a work made for hire. So the Willis case, which was the Village People guy, he was terminating a songwriting agreement that did not have work for hire language in it. So that issue is still very cloudy as it relates to the record labels, whether recording artists are in fact employees for hire in their recording contracts. Songwriting agreements tend not to have so much of a work for hire obstacle. Right. But certainly the issue is on a lot of people's radar right now. And if you have contracts that go back to that period of time, it's really start looking at them and thinking about when your termination window opens. I'm not going to go into all the statutory details. It's all in the Copyright Act. But there's a window of time in which you have to do this or you lose your right to recapture.
And from what I understand, Congress didn't try to make it easy.
No.
They got out their best, people at obstacle runs and wrote a law that's extremely difficult to navigate. So my recommendation would be you need to hire a lawyer to help you get this back and to do it in the right way. Unless you're really sophisticated and really familiar with the law, I don't see any other way around that because it's diabolical, may I say?
It's a great legal employment act.
Well,
For a long period of time.
Yeah, you guys must have paid them a fortune.
They must have.
The SGA has been very active in helping SGA members, I think.
Yes, Songwriters Guild has been very, very active on this. Yeah, you're absolutely right. So.
And then it also only applies in the U.S. It doesn't apply ex-North America, which has a whole slew of additional problems. And then the other question is, which I don't have the answer, can you terminate a grant a license to BMI, ASCAP, or CSAC, because they are not acquiring the copyright.
Well, it's a grant of any rights. Yeah. Well, no. I guess you're not granting them a right. You're making them your licensing
Given a
agent.
license, yeah.
Right.
Yeah. That's a good question. But certainly, it doesn't apply outside the U.S. and it also doesn't apply to derivative works. You can only terminate the grant that you made originally.
Right.
So if someone then later made a new arrangement of your song, they can continue to exploit that arrangement even after you take the song back. So it's limited, and it's all back to what Doug said, that Congress didn't want to make this easy. They were getting a lot of pushback from the publishers of the world and the movie studios and the record labels of the world when they drafted this, and it's really sort of a halfway measure to try to even the leverage a little bit.
Yeah.
We
Good.
should talk about what the motivation for it was. I mean, why did the songwriters care about this?
Well, they care about it because if you can get your rights back from a publisher, if you're under a publishing agreement that is, you entered into when you were just starting out,
Yeah,
and
16 years old, you signed a songwriter agreement.
and and you still haven't made your delivery commitment because of the way they're
Yeah.
calculating everything, you can get out of that agreement and do a lot better deal for yourself. And in fact, the way the law is written, once you serve your notice of termination, it has to be at least 2 years before the effective date of the termination. And you can negotiate with your original publisher for a new deal in that period, before the termination takes effect. And failing that, you can go down the street and sell
Shop
your
for
work
a
to
deal.
somebody else.
Yeah.
Get a better deal for it.
And that's where the leverage has started to shift, where it becomes
Right, because
it
once
gives you
you-
that second bite at the apple.
Once you have
Sure.
become Bruce Springsteen,
Yeah.
your deal from 1978 is probably not as good as the deal you could get today.